Thank you very much. It's great to be here. Thank you to Alzheimer's Australia WA for the invitation to speak to you today. And Sean, thank you also for the welcome to country. I'd like to acknowledge the traditional custodians of the land on which we meet and pay my respects to their elders past and present. And as Sean said, there are no separations. So I also like to acknowledge the elders of all the cultures that make up this wonderful country of Australia, including my own ancestors. I recently found a convict in the family tree. Yay! You realise that convicts are Australian royalty, don't you? And coming from Ireland, I thought, what did he do? Did he steal a loaf of bread to feed the starving children? Not in our family. He was convicted of bigamy. Okay, so today we're going to talk about advanced care planning with people with dementia, promoting autonomy and human rights. Now, the context for this is that better living conditions and healthcare have led to increased longevity. You may know that in the last census there were almost 4,000 people in Australia over 100, many of them still living at home well and happily. Now, this is a success story, no matter what rubbish you hear in the newspapers about the problems of an ageing population. What do they want? They want us to go back to 1900, where average life expectancy was 50? I don't think so. In addition, rapid technological development has allowed people who would previously have died to be kept alive for long periods of time, often through the use of such things as ventilators and feeding tubes. But these very successes have led to practical, legal and ethical issues, in particular around end-of-life care and extending the dying process, including for the increasing number of people with dementia. Now, you heard me say number, not percentages. The ratio is not going up, it's the numbers that are going up, again, despite what the shock jocks will tell you. So in my research, I've had stories about loved ones left hooked up to machines until the very end. We couldn't even get close enough to give him a hug and say goodbye. Another woman told me Mum always said she wouldn't want to be resuscitated if her heart stopped, but they wouldn't listen. This next one is very, very important. This was a man in his late 80s, had multiple problems, still had capacity, but he had decided he'd had enough. He decided he would stop eating and drinking. His wife said, first of all, he was stubborn when he was in hospital. He wouldn't eat. He was just starving himself. They couldn't get him to eat, so they had to force feed him. They put a tube down his nose, and then they had to tie him in the bed because he kept pulling it out. He just didn't want it. That is a clear case of criminal assault. And if his wife had known the law, she could have taken action. I'll talk more about capacity later, and forgive me if I race through some of this because I know we have limited time. But let's have a think about provision of food and fluid. Now, you would probably know that loss of the swallowing reflex is a normal part of advanced dementia. It's also often a part of the dying phase of people who don't have dementia, or people who are dying often simply don't want to eat or drink anymore. There's a lovely, gentle phrase they use in Europe. It's called putting down the spoon. People reach a point where they put down the spoon. So if a dying person doesn't want to eat or drink, this should be respected. And if a person with advanced dementia turns their head away or pushes away the food or the cup, even if they still have swallowing ability, this can be accepted as refusal. Families often think, oh, if we could just get him to eat something, he'd get his strength back. He wouldn't. He's dying. They need information, support, counselling, and it is not okay to harm your resident client patient in order to please or soothe their family. The person with dementia the dying person shouldn't be fed with a tube, and to do that risks not only increasing their suffering, but can deprive them of a peaceful death. Let me explain. If a person has entered their dying and you artificially continue to feed them, you can cause nausea and vomiting, scouring, all sorts of problems. If you continue to artificially hydrate them, you can cause swelling and edema and they can drown in their own body fluids, unless you put a tube in the other end to take it back out again. All of that is bad enough. Worse still, you can increase their suffering, but the human organism is designed to recognise when death is approaching and to release endorphins that act like a natural analgesic. Many of you will have seen people who are terminally restless and then at the very end they become calm and euphoric. That's because the body has released the endorphins. If you artificially feed and hydrate someone, the body doesn't get the signal, doesn't release the endorphins, you can deprive the person of a peaceful death. The other thing to tell families is that if a person has entered their dying phase, they're not going to be feeling the hunger and thirst problems that healthy people would be feeling. Now, a lot of the problems I've just talked to you about come from confusion about what is and what is not euthanasia. And that leads to inadequate pain management, it leads to inappropriate use of medical technology, it leads to fear among health professionals about the legal consequences of care provision, it leads to poor doctor-patient communication and disillusioned patients, families and carers. Some commonly held beliefs are that euthanasia includes giving increasing amounts of needed pain relief, which may also have the effect of shortening the person's life, or respecting a person's right to refuse further treatment, or withholding or withdrawing life support systems that have ceased to be effective, or that will provide no real benefit to the patient from the patient's perspective. None of those is euthanasia. The World Medical Association defines euthanasia as the deliberate ending of a person's life at his or her request using drugs to accelerate death. In the studies my colleagues and I have done in Australia and Europe, we think the definition that describes it best is that euthanasia is a deliberate act intended, and that's the most important word in the definition, intended to cause the death of the patient at that patient's request for what he or she sees as being in his or her best interest. It's active, it's voluntary, it's euthanasia in its original meaning of the term of a good or peaceful death. But let's look at some of the things that are legal now and that are not euthanasia. Giving increasing amounts of needed pain relief, which may also shorten the patient's life, is often referred to as the doctrine of double effect. The primary intention is to ease pain. A foreseen, unintended secondary consequence may be, but usually isn't, the hastening of the person's death by a few hours or days. This is accepted by most religious and medical groups, including those who strongly oppose euthanasia. For example, the Catholic Church accepts the doctrine of double effect because the first person to use the term was St. Thomas Aquinas. Aquinas said, if you must achieve a good end, in this case relief of pain, and the only way you can achieve that good end is to also run the risk of a foreseen but unintended secondary consequence, you must still achieve the good end. There is no excuse for leaving a terminally ill person in pain. Zero, zilch, bottom line, nil. I do get a bit passionate about this, don't I? Okay. But you know what? The irony of all of this is not giving adequate pain treatment when it's needed may shorten life. The patient can suffer complications such as life-threatening cramps or respiratory distress if severe pain's left untreated. So you get these numbskulls who say, oh, we can't give them any more pain relief because that might be euthanasia. We might hasten their death. So you leave them in agony and hasten their death. Duh. Not much going on in the top story, I can tell you in that one. And you know what? Not providing pain relief for someone who is terminally ill is a human rights abuse. And the sad thing is there's evidence, good evidence, that people with dementia often receive less than adequate pain treatment. They can't say, and nobody's watching. And there are good scales, visual scales that you can use. Now, we all need to be vigilant to ensure that a person receives adequate pain relief. Let me tell you a little story. My sister died in September 2012, acute onset leukaemia, 10 days from diagnosis to death. She won't be surprised, being my sister, she had written her advance directive and she had appointed her substitute decision maker. And there were a few little challenges in the first week. But on the last day, she'd lost capacity by this stage. I'd been with her most of the day. And I went home and my niece phoned me about an hour later and she said, "Oh, Nicole, I'm sure she's in pain. And I just spoke to a nurse and she said we gave her something 2 hours ago." I went, "Anne-Marie, you are not telling me they are still prescribing pain relief for terminally ill patients 4-hourly. What century are they living in?" I said to her, "Are you up for another challenge?" She said, "Yep." I said, "Right, out to the desk, pretend you're me." And I said, "Say to the nurse, my mother's in pain, that's unacceptable, please have something done about it." So she did. And the nurse went, "Oh, okay," turned to the man standing with his back to Annie and said, "Dr. X, could you please go and check Mrs. Garcia? Her daughter said she's in pain." He went, "Yep." In he went, checked her file, up to morphine, up to midazolam, and said to the nurses, she gets breakthrough medication every 5 minutes if she needs it. If she needs it. My sister died without pain because she had a patient advocate. Please be patient advocates if you need to be for the people you care for and care about. Respecting a patient's right to refuse treatment, I've already told you, is a legal and moral right possessed by every competent person under the common law in every state and territory of Australia, and in those states and territories that have a criminal code, under the section of the criminal code relating to assault. If I say, don't touch me, and you do, I can have you for assault. It's also the right of someone who isn't competent now, but who, when they were, completed an advance directive or appointed someone to make decisions for them. And withdrawing or withholding futile life support systems used to be called passive euthanasia. Please don't use that term. It's no form of euthanasia, and there's general agreement that using it can lead to the inappropriate continued use of invasive technology. And often, the technology is not prolonging life. It is merely prolonging the dying process. If I'm on my dying trajectory and you interrupt that process by putting in a ventilator or a feeding tube or a dialysis machine or some other form of technology, and after a time you realise you can't return me to any sort of quality of life, all you have done is put a roadblock in my dying. And if you remove that impediment to my dying that you put in the first place and allow my natural dying to continue, keeping me comfortable in the process, that has nothing whatsoever to do with euthanasia. Removal of futile treatment is good medical practice. There is one little glitch, there's no definition of futility in the law, but it's generally agreed to be when burden outweighs benefit. But burden and benefit should only ever be from the viewpoint of the person whose life it is. Now, in studies that my colleagues and I did in Queensland and the Northern Territory, we asked people, if you were terminally ill, what do you think would cause you the most distress? In every study we did, loss of mental faculties came in first. In every study we did, loss of control came in second. In the first study, you can see second last on the item here, we had extreme pain and it came in at number 3. Then the research team said, why have we got extreme pain on this list? If someone's in extreme pain, they should sue their doctor. We changed it simply to physical pain, and in the second study it dropped down to number 6 in the list. In the third study, it dropped down to number 8. The more items we added in, the further down the list it went. People were not afraid of pain. In every study we did, death itself came in last. Every study we did. People were not afraid of dying. They were afraid of loss of mental faculties, control, independence and dignity, being a burden on families. These things were of much more concern to people than death itself. You know, every time I see this slide, it reminds me of Woody Allen. Woody Allen said, I'm not afraid of dying, I just don't want to be there when it happens. I kind of do want to be there, but I want it to be right. Okay, now a major issue in relation to loss of mental faculties and control and independence is preservation of autonomy and how capacity is assessed. And I'll return to that a little later. So in WA, you can undertake advanced planning to help address some of these fears and concerns. You can appoint an enduring power of attorney to take care of your financial matters. For your personal and healthcare matters, you can write an advance directive or appoint an enduring guardian. Now, I'm not going to talk any more about the financial part, just to say to you, if someone comes to you with an enduring power of attorney, they do not have the right to make personal and healthcare decisions for the person for whom they are holding that power. They need to have an enduring guardianship appointment to have that power. It's really important that you get that clear. Now, advanced care planning is a process, not just a signature on a piece of paper, that allows a person to make and communicate in advance decisions about their health and personal care, including medical and dental treatment, for a future time when they may have lost capacity. Ideally, it involves a discussion between the person and their healthcare provider, their primary care, etc., about their values and beliefs about end-of-life care. Now, that's ideal, but if a person wants to undertake advanced care planning and doesn't want to talk to anybody, they mightn't want to talk to their family and they mightn't want to talk to their doctor, they can still do that and the document is still valid. For it to be fully effective, it also needs to include recording those discussions. Now, people sometimes say to me, oh, it's the conversation that's the most important. Yes, the conversations are important, but if you don't complete the advance directive, then if the time comes, could be some years later, the family are having a brawl about what should or shouldn't happen. You've got the evidence if you've got the advance directive. Or the person might be under the care of another medical practitioner who doesn't agree with what they've said. They are legally binding. It's good if you've got it done. So, and an advance directive is a legally binding written document which allows a person to make their wishes for future healthcare known. It extends the current right of a competent person to refuse treatment to a future time when they may not be competent. It is not a form of euthanasia. It only allows actions which a person could legally consent to for themselves if they were competent to speak. And it only comes into effect when the person making it has lost capacity. Now, a diagnosis of dementia for someone may cause a range of emotions for the person themselves or for those close to them, including grief, disbelief, anger, shock. Even sometimes you will have seen relief. At least people know why what's been happening has been happening. And knowing the diagnosis at an early stage allows time for setting up good supports and planning for expected changes as the disease progresses. And the good thing about it is the person with dementia can participate in the planning process and ensure that his or her wishes for end-of-life care are known and documented. You should see the relief on people's faces, some of you may have, when they have completed their documents and they know that as the disease progresses, people will know what they wanted, and particularly when they understand that these documents are legally binding. Now, that slide I put up, where I showed you what people were most concerned about, what was right on top? Who was paying attention? Loss of mental faculties. Oh, you can all go to the top of the class, righto. These come into effect when the person has lost their mental faculties. What was second? Loss of control. Very good. Okay, this gives control back to the patient. It ensures the patient's wishes are known because it's the patient's own words. It also assists healthcare providers with decision making. I remember when we got the legislation through in Queensland, the Director of Intensive Care at Townsville Hospital contacted me and said, "Thank you for these documents. When someone comes unconscious into my department now, at least I have some idea of what they might want." It also relieves family stress at times of trauma. You would know that times of stress and trauma can bring out both the best and the worst in families. And if there's no planning done and someone has to say switch off the machine, at every wedding and funeral from then on when someone's had a few jars, "You killed my mother." Yes. Right? Yes. Well, if you have the document and you say at the time, "All I'm doing is making sure that mum's wishes are respected," you can stop families fracturing. Now, it also gives security in relation to future events. Excuse me, I've got to pour a glass of water. Every time I talk too much, I get dry mouth. Now, I hope my house doesn't burn down, but I've got an insurance policy against that. I hope I don't have a car accident. I've got an insurance policy against that as well. I hope I'll never be terminally ill and I can't speak for myself. I've got an insurance policy against that as well. I've written my advance directive and I've appointed my substitute decision makers to make sure that what I've got written is respected and to make any other decisions that are needed. Now, that's a little tip you can use when you're introducing advanced care planning to some of your residents and clients, etc. Talk about it like an insurance policy. You hope it's never needed. It's great if it's there if you do. So let's look at the next option in WA. You can appoint a competent person aged 18 or over can appoint an enduring guardian to make personal and lifestyle decisions or decisions about medical and dental treatment on their behalf in case they lose capacity. And you can appoint anyone aged 18 or over who has capacity, but usually it's a trusted relative or friend. Now, I have a few problems with your legislation in WA, and I'll tell you as we go through. And of course, everybody, you know, this is your law, and if you agree with me, you might need to think about whether you can have a chat about having some amendments made. In WA, you can appoint more than one enduring guardian, but if you do, they must act jointly. Now, this is not an ideal situation. You can appoint someone in case one of the originals dies or is incapacitated, but that doesn't give you enough options. In a lot of the other states and territories, there are various options. For example, when I was making mine, I phoned my son and I said, Steve, am I right in thinking you'd be happy to have my enduring power of attorney for finances, but you would prefer that Kimmy has my enduring guardianship for healthcare? He said, oh, absolutely, Mum, because she'll do as you tell her and I won't. Oh, great. And he said, no, I know you. You'd say, if I'm in that condition, don't let them do any more tests or operations. But I'd want to bring in every specialist that existed and keep you going to the last gasp. But Kim will do as you tell her. So I phoned my daughter and I said, is this okay by you? She said, of course it is, Mum, but isn't it typical? The boys get to look after the money and the girls get to do the caring. But because in Queensland you can appoint more than one and you can say how they're to make their decisions, on my healthcare, Kim's first, Steve's second, my close friend Barbara's third, and if Kim's off overseas, she doesn't have to die or become incapacitated as per here for someone else to move up. If she isn't around, Steve will make the decisions, and I've told him if he makes the wrong one, I'll come back and haunt him. Quite simple, really. And if both of them happen to be, off on bushwalks or somewhere else, my close friend will move up and and they all know what I want. And believe me, they better do it. Okay, and the person that you appoint has to agree to the appointment, should understand your wishes and be prepared to carry them out, and the appointment has to be in writing in the approved form. This brings me to the next point in the WA legislation that I'm not happy about. That is, it has to be signed by the person themselves, by the people you've appointed, and by 2 witnesses, as opposed to 1 in the other states, and they all have to be together. The witnesses must sign in the presence of the person, the enduring guardians, and each other. In my case, trying to get that to happen would have been almost impossible. Steve lives in Sydney, Barb lives in Brisbane, Kim's at the Gold Coast, and getting 2 witnesses and me and all of them together at the same time would be a very big ask. I don't know how you do it here. I don't know whether, you have people who the people they want to appoint are spread out around the country as well. But I find that a little bit of a problem with the law here. Now, before... and also enduring guardian provision only comes into effect when the person making it has lost capacity. So if someone comes in and your client still has enough capacity to make their own decisions and the person says, oh no, but she can't do that, I've got enduring guardianship, so I'm telling you what will happen. No, you're not. We will be doing our best to help this person make her own or his own decisions for as long as possible. My colleagues and I recently did some research that I want to share just one little scenario with you before we talk about what happens if you haven't written your advance directive and you haven't appointed your enduring guardian. So this is about Jenny, 55 years old, diagnosed with motor neurone disease 6 months ago. She's taken unconscious to hospital after a car accident, stable but still not able to make her own decisions, and decisions are needed about her medical treatment. Her husband Peter is listed as next of kin on the previous hospital records, but they've been separated for many years and don't see each other often. They have 2 adult children. Michael, the oldest, has enduring power of attorney for Jenny, and Sarah has recently taken 3 months leave to care for her mum full time. And for the last 5 years, Jenny's lived with her same-sex partner, Susan. Now, all 4 of them are together at the bedside. Who would be legally entitled in WA to make their decisions? Hands up who thinks it would be Peter. Okay, a few of you think it might be Peter. Okay, Michael? Good, you all got that message. Michael has enduring power of attorney for finances, not healthcare. Okay, Sarah? Susan? Okay, got a bit of uncertainty, haven't we? Let's see what the law says in WA. If you haven't written an advance directive, you haven't appointed your own enduring guardian, and there's no guardian appointed by the tribunal, then under the legislation, under the person responsible section of your legislation, it's the first of the following adults of full legal capacity, reasonably available, willing to make the treatment decisions, and has close personal relationship with the person. So a spouse, including de facto or same-sex partner, and in your legislation, adult son or daughter, parent, sibling, non-professional carer, person with a close personal relationship. So now, who do you think would have the right to make Jenny's decisions? Hands up who still says Peter. Close personal relationship. Haven't seen each other for months. Hang on, we're getting there. Michael? No. Sarah? No. Susan? Yeah, okay. Susan has the right to make her decisions. A spouse, including de facto or same-sex partner, who has a close personal relationship. Now, the only problem I have here with your order of authority, again, it's different to a lot of other states and territories, New South Wales, Queensland, Tasmania, Victoria. Where you have non-professional carer, in the other states and territories it follows spouse. So if a person doesn't have a spouse, and lots of older people, and not so older people, don't have a spouse, but you might have a very close friend who's been coming in and taking you to the doctor and looking after you and helping you with your shopping and your washing, that person is probably more likely to know what you would want than many of the other people listed there. So in my case, I have appointed both my adult daughter and my adult son as enduring guardians, but if I hadn't, then I would want someone who understood what I wanted. And I sure as heck wouldn't want it to be my sister who's an RN and would come in and try and take over. Okay. So that's another area that I think is a little problem with your legislation. And I don't mean to be critical of your legislation, but it's got a couple of little problems. So, introducing the topic. When's the best time to raise the subject? Well, ideally by the GP when the person's reasonably well. This should be happening much, much more out in the community. Because it's not just for older people. Any one of you could be injured in a car accident or in the surf or have a stroke or a sudden heart attack. In reality, most people coming into your service won't have completed their advanced care planning, although some will have given people enduring power of attorney. Now, don't start the conversation on the day of admission so they think, oh, they think I'm dying. You can ask them, have they done it? But wait until they've settled in. Be alert for cues. I'm afraid of what will happen. Now, you can say, would you like to talk about what's important to you and what you want us to know if you can't tell us yourself? Or what are the things you're most concerned about? And a helpful tip, the insurance policy one can work as well. I absolutely acknowledge how flat out you all are all the time. I know that. And it does take time to have these discussions. But it can be very, very helpful to you when a crisis occurs and you know what the person would want and who has the right to speak for them. But the person themselves, the look of relief I've seen on people's faces when they've done their planning is pretty impressive. Now, let's think about this issue of capacity. No, before we do that, how many of you have given someone enduring guardianship? 1, 2, 3. Okay, how many of you have written your own advance directive? Oh, shame on you. Oh, so you're all going to go on till you're 150 and just fall off your perch, is that right?
All Western Australians will.
Of course. Or you'll just leave those terrible decisions to your family. Nice. I don't think so. Best of British. Okay, so let's have a look at the issue of capacity. When does a person have capacity? The legislation throughout Australia is based on the United Nations principle of presumption of capacity. I don't have to prove to you that I'm competent. I'm competent unless you can prove I'm not. The onus of proof is not on me. It's on the person making that decision. If you are unsure, if there does seem to be a little trigger, some uncertainty, the person has to understand the nature and the effect of the decision to be made. I'm a JP in Queensland, and one old lady brought her document to me to witness, and I took it from her and I said, tell me what you think this document's about. She said, well, it's about what treatment I want or I don't want if I can't speak for myself in the future. Yep, that's what it's about. And on here you've said, if you're in a persistent vegetative state. It's defined in the document. I said, what do you think that means? She said, well, it means I'm unconscious and I'm breathing and stuff and I could have my eyes open, but I'll never really be conscious again. Close enough for the purpose of the exercise. She didn't need to tell me what a pathology was or what a blood gases were doing. I said, well, you've said if you're in that condition, you don't want CPR. What's that mean? She said, well, it means if my heart stops, they're not going to push on it to make it go or give me a shock to make it go. I said, then what would happen? She said, well, then I'd die, but I'd rather die than be like that. She understood the nature and the effect of her decisions. I had no problems witnessing her document. The person also has to be able to communicate their decision in some way, not necessarily by speaking or writing. Body language may be adequate. I was called to the spinal unit at PA Hospital one time to witness a document, and this man had been in a serious car accident. They thought he was tetraplegic, but he recovered the ability to nod and shake his head. Been on a ventilator, taken off 3 weeks before, didn't want to go back on. He'd been told if you don't go back on, you will die. He didn't want to go back on. His wife, his mother, his intensive care specialist and his spinal unit specialist all said he knew what he was doing. His sister said he didn't, and she brought in 2 psychiatrists who also said he didn't. The case went to the Guardianship Tribunal, which start from presumption of capacity and said bring in your experts and prove it. At the end of the trial, the tribunal said, you have not proven that he lacks capacity. So I was asked to come and watch the process and witness. And the doctor walked him through. If your heart stops, do you want CPR? If you can't breathe, do you want us to put you back on the ventilator? Thought he'd shake his head off his shoulders. If you can't swallow, do you want us to feed you with a tube? No, no, no. And then it gets to a bit where it says other. And they said to me, what else should we ask him? And I said, well, what other treatment is he facing? Because it's actually easier to craft a really good directive for someone who already has a diagnosis and you know what they're facing. They said chest physio. I said, okay, ask him. Do you want chest physio? And he said, yes. I thought, uh-oh, do we have an inconsistency? Does he really have capacity? And they said, no, he hates chest physio, but he knows it makes him comfortable, and we've promised him we would never use it to prolong his life. Now, for me, that confirmed his capacity. He could distinguish between those things. His wife signed on his behalf, his doctor signed, I witnessed it, and that man died 3 weeks later, which was absolutely appropriate because he had decided that his quality of life was so poor he didn't want his dying prolonged artificially. Now, nearly finished. Incapacity is not ignorance. If you haven't been given adequate information, that says nothing about your capacity. Eccentricity, cultural diversity, or having different ethical views is also no evidence of incapacity. Neither is communication failure. I have seen woeful communication in some situations. Having a diagnosis of dementia is no evidence of incapacity. At some levels you would still have, at others you may not. Hands up anyone in this room who has never made a bad decision. Oh, gee, that's wonderful. Usually I get one person, one clown in every circus. None. Yeah, me too. I've made some doozies in my day. Don't think I lack capacity at the time, but I wouldn't put money on it. And disagreeing with your healthcare provider is no evidence of incapacity. You're such a wonderful audience, I've got to tell you about this one. You know the slide where I showed you that most people are not afraid of dying, but some people have a really clear idea of how it's going to be after they die. For example, a famous physician died and he went up to heaven, and when he got to the pearly gates, he smiled at St. Peter and went to walk straight through. St. Peter said, excuse me, go to the back of the line, please. Oh, my good man, you obviously don't know who I am. St. Peter said, doesn't matter who you are, up here everyone's equal. Go to the back of the line, please. Well, he was not impressed. He didn't think heaven was going to be like this. And then about half an hour later, a famous surgeon died and the same thing happened. Fronts up to St. Peter and goes to walk straight through. And St. Peter said, excuse me, go to the back of the line, please. But I invented the surgical procedure. Doesn't matter. Up here, everyone's equal. Go to the back of the line, please. So the pair of them are back there and they are not happy campers, especially when a few minutes later, this guy in a white coat with a stethoscope round his neck fronts up to St. Peter, smiles, waves and goes straight through. Well, this is too much. So the pair of them go charging up to St. Peter and they say, excuse us, you made us go to the back of the line, but you let him go straight through. St. Peter said, oh, don't mind him. That's God. He just thinks he's a doctor. Sorry, I had down a note, tell the joke if you've got time, and I'm running out of time. But just quickly tell me how many of you in your service or senior staff use the mini mental state exam to determine capacity? None of you. I love you forever. The mini mental state exam is not designed to test capacity, it's a screening tool. There is good evidence it should not be used for older people and people with low education or Aboriginal people or people from non-English speaking backgrounds. Who does it get used for? older people, people with low education, etc. I don't have time to give you the cases now. Better to provide the information, check comprehension. I've got a few documents that you might like to have a look at. The GP COG is better than the MMSE. The RUDAS is much better for Aboriginal people and people from non-English speaking background. And Professor Petrus Darjan's designed a 6-step capacity assessment instrument for Alzheimer's South Australia, which is also very good. Now, 3 more slides to go. There is an emerging issue you all need to be aware of, and that is supported decision making. There's a very strong move to supported rather than substitute decision making, and the main drive for this is from the disability lobby, but it also applies to people with dementia. And it uses a social rather than a medical model of health, and what can't this person do is the medical model, but what could they do with support? The aim is to facilitate autonomy and self-determination, to provide assistance for the person to make their own decisions to the absolute maximum extent that they can. Now, advanced care planning is one form of this in the early stages perhaps of dementia, but there are other ways. Remove the barriers, give the person time, a quiet environment, and as I said, body language may be sufficient. And the person who's turning their head away is making their decisions. So that's your order of authority. If there is an advance directive and it does meet the current situation, it holds, it's legally binding. If there's not and the person's appointed an enduring guardian or there's been a guardian appointed by the State Administration Tribunal, if there's none of those, I gave you the list of person responsible, and if there's none of those, then you might have to apply to the tribunal for appointment of a guardian, but they would only do that when there's a demonstrated need. If everything's going well and the person's being well cared for, they probably wouldn't. And finally, our carers, our wonderful, wonderful, wonderful carers. A major stress among carers of people with dementia is not knowing what's the right thing to do and being afraid of doing the wrong thing. Some of that stress can be relieved with appropriate advanced care planning. And carers of people with dementia, as you would all know very well, often carry extremely heavy burdens and they need all the support we can give them. Thank you.